We're on.
Okay, we're ready to go. Good afternoon, everyone. Thank you for attending the BIA webinar on Land Use 101. We appreciate you taking the time to join us today. I think you're going to find this worth the time you're committing to it. I wanted to start by saying, if you have any questions, place the questions in the chat box, and then we will ask David as we move along, because it is a pretty information-filled presentation. But before we get started, I just wanted to take a minute and tell you a little bit about our presenter today. As you know, San Diego land use and attorneys go hand in hand, and we're very proud to have a true master of his craft here today. David Watson is an expert in real estate law, land use planning, entitlement. He represents land developers, home builders, and he also has clients in the education field, tourism, and even hospitality industries. He served on as counsel in the development and approval of master plans for some of San Diego's major universities, and he currently serves on the BIA Board of Directors. He's also served as a planning commissioner for the city of San Diego and the Board of Directors of the San Diego County Fair, which many of you may not know is one of the 5 largest fairs in North America. His land use seminars continue to grow in importance and also in popularity, and we absolutely thank him for being with us today and to share his expertise. So with that, I'll throw it over to you, David.
Matt, thank you so much. When you make that introduction, I'm thinking back of a 32-year career, and I think, wow, how did I do all that? Where did I find the time? But anyway, thank you.
Yeah, a few more years, I'd have to go to a second page on the introductions.
Right, right. Today's presentation was created as a result of a conversation that Matt and I had 3 or 4 years ago. We were talking about the fact that when newly elected public officials come into office and we start discussing land use regulations with them, like most new public officials and most members of the public, they don't fully grasp the breadth and depth of all the federal, state, and local laws and regulations that you have to comply with in order to do a major project in California. So we put together this presentation to sort of as a basic introduction to, gee folks, this is everything we have to contend with. This presentation is not intended to be a seminar on any individual topic. Each one of these topics, you could go spend days discussing them, especially the California Environmental Quality Act. But the point of the presentation is to leave all of you with the idea that the reason, one of the main reasons that housing is so expensive is because of these regulatory hurdles we all have to go through. So with that, Danielle, if you could start the PowerPoint, that would be great. Okay, Daniel, why don't you go to the next slide and then the next slide. Let's go straight to general plans. Now we're going to start at the local level. In the world of land use law, the general plan is considered by our state courts to be the constitution of local jurisdiction. It's the highest in the hierarchy of local land use regulation, and all local jurisdictions must adopt general plans. And the reason general plans are so important is that whenever you get a project approval, such as a site development permit or a conditional use permit, or many, many other approvals, they all have to be consistent with the general plan. General plans contain text, diagrams, policies, regulations, and 7 mandatory elements, including land use, circulation, open space, et cetera, et cetera. Let's go to the next slide. Let's talk about specific plans. Now, California law also allows local jurisdictions to adopt specific plans. And that's where if you have a large piece of property, like 10 acres or 200 acres or 1,000 acres or whatever, and you want to do a full-scale development, you can basically write your own rules. You can write your own zoning, height requirements, your own design guidelines, basically to supersede and give yourself more flexibility than the zoning code might allow. And these specific plans, again, must be consistent with the general plan, but they are a tool for flexibility. Two of the most recent specific plans I worked on, even though they didn't do well politically at the ballot, in Del Mar, we were doing a 15-acre specific plan for a resort right at the end of Via de la Valle, across from the Brigantine restaurant. And that was basically would have written we wrote our own rules for development of a resort on that property. And the other recent one I worked on was in Carlsbad for the Caruso development that was over 100 acres of agricultural land as well as commercial shopping. Those were both specific plans that wrote their own rules because they were legislative, they were subject to ballot measures and they didn't pass, but that is how a specific plan works. Another plan that's on the books are multi-species conservation plans. You can go to the next one, Danielle. MHPA plans are authorized by federal and state statutes. And in a very simplified word, they basically are plans that say, here you can develop here and you can't develop there. They are intended to protect sensitive habitat while allowing for a certain level of development. I know the BIA was very involved in the formation of the City of San Diego MSCP. This was more than 20 years ago. I was on the Planning Commission in the 1990s when we did San Diego's MHPA, and that's where I first met Matt. He was speaking to us about this plan. So, okay, next slide. Zoning.
Hey, David, I had one quick question on the MSCP.
Sure.
Now, 20 years ago, when they were first developed, it was San Diego was still developing in greenfield areas. But now, as the tide has kind of shifted and we're looking more to go vertical rather than horizontal, do you think multiple species plans are still valuable today?
Well, you would be surprised where the MSCP boundaries are in the city of San Diego. So it's wise, if you're looking at developing a piece of property, even if you're in an urban area, it's wise to look at the map and figure that out. So are they valuable? I would assume that depends on who you talk to, on which side of the equation you're on, but are they relevant? Definitely, because you need to keep an eye on, like for instance, large swaths of Balboa Park are in the MSCP around the inner city core. And it's surprising how this map will affect what you want to do once in a while. So just keep it in mind as something that you want to be aware of, even if you're developing in an urban core area. And if you're outside the urban core, definitely keep an eye on where the map boundaries are. So, and out in the county as well. So, all right, let's go to zoning. Danielle, okay. Now zoning is a step down from a plan and it's intended to provide detailed regulations of uses. It also is intended to provide for public safety. You don't want a warehouse next to a school or an industrial use next to a residence. Zoning is an outgrowth of what used to be nuisance law. Before there was zoning, people had to sue each other for creating public or private nuisances, and zoning eliminates a lot of that. Zoning generally needs to be consistent with your general plan unless you're a charter city or the city of LA, but most cities try to be consistent anyway. Let's go to the next slide real quick. Within zoning rules, there are procedures for deviations and variance from the basic rules. There are rules that occur for non-conforming uses. What happens when you built your development and it was legal and then the rules change later? The city of San Diego has a pretty detailed previously conforming use provision. And you know, zoning, that's where you find your height limits, your floor area ratios, your setbacks, signage rules, things like that. Special overlay zones apply. If you're near an airport, you're probably having to deal with airport issues, sensitive habitat, or I think San Diego has parking overlay zones. You need to check if there are any overlay zones if you're going to be developing a piece of property. Zoning is also where you will find your affordable housing requirements, your inclusionary zoning requirements, and things like that. So zoning basically is where you find the details of the policies that you find in a general plan. Next slide. Redevelopment, real quick. Redevelopment law has been abolished in California several years ago, but there's a long, complicated wind down process. Smaller cities are basically done with that process. Larger cities are still underway. The only point I want to make here is if you're looking at a piece of property to develop that was formerly owned by a redevelopment agency, you want to check and see where that property is in the wind down process. If it's out and sold already previously to a private owner, you don't have to worry much about it. But if it's still in the being overseen by an oversight board or the successor to a redevelopment agency, then you need to check on what those rules might be. And they're going to be different in every jurisdiction. So, okay, next slide. This is just because of happenstance or my clientele, I'm not quite sure. I do a lot of work in the coastal zone. The Coastal Act created an area of the state, generally west of 5, that requires compliance with any local coastal program if it's been enacted by the local jurisdiction. And that means you need a coastal development permit. Any development in the coastal zone is subject to the Coastal Act. The biggest client I deal with on a regular basis is SeaWorld. They are in Mission Bay Park. They are in the coastal zone. And Mission Bay Park is a former wetland and a former marshland. Therefore, the Coastal Commission has original jurisdiction over that area, so they issue every single coastal permit for Mission Bay Park. That includes all the hotels, anything the city wants to do. Now, SeaWorld, for instance, every little thing they build has to go to the Coastal Commission. So whether it's replacing a toilet area or building a massive new attraction, so it's an interesting process. The Coastal Act has very specific planning and design guidelines. If you try to follow them, for the most part, you should be okay. But if you're trying to build a development in a wetland, probably not going to happen in the coastal zone. So anyway, if there's any questions about the Coastal Act, I'm happy to talk more about the nuances and the life of the Coastal Commission, but I'll move on to the next major act that we all have to worry about is the Subdivision Map Act. Any land that's going to be divided to be sold, leased, or financed needs, okay, something wrong, Danielle. Can you fix the screen?
Yep,
Thank
there you go.
Go to Subdivision Map Act. Next slide, Danielle. Okay, Danielle, do you need to fix the slide?
Well, we can see a smaller version of it as well. So much
Well,
just
I'll
keep
talk about it real quick.
work that out.
Basically, any property that's going to be subdivided needs to be, sold, needs a map act. Normally, you get a tentative map, two-step process approved as a discretionary process, and then you will record a final map. Typically, there are dozens of conditions attached to a tentative map with which you have to comply, and there's typically a subdivision improvement agreement that goes with a tentative map that contains all the requirements for obtaining a final map. The Subdivision Map Act also allows for a best in tentative map that allows you to develop in accordance with the rules that were in effect with the at the time the map that was approved. So, and then the next slide. Danielle, can you see how messed up this is? And
Go ahead.
Can you just minimize that middle part? Great, thanks. Okay, go back to site development permit.
Nope, go back.
Okay, there we go. Now, there are lots of uses that are considered desirable, but they need special review. At least these are what the local jurisdictions believe. And there are different types of permits that allow these uses: conditional use permits, plan development permits, neighborhood development permits. The biggest example that everyone sees whenever they drive down the 8 or 5 freeway is University of San Diego. We just updated the University of San Diego master plan. All the underlying zoning for USD is residential. And so what USD needs is a conditional use permit to allow itself to exist. And along with the conditional use permit, USD has a plan development permit and a site development permit because it has sensitive resources throughout its campus. And so I've been working on USD's master plan twice, the first time back in 1996, then the most recent in 2017. And so we have amended all these permits twice now with an EIR, a subsequent EIR, and it's been a 3 to 4 year process, but it allows USD to be on that site. It controls the number of students that USD is allowed to enroll, and it controls other things like traffic improvements, circulation, and things like that. So that's the most prominent example of use permits allowing uses that may not necessarily be authorized by zoning. Next slide. Let's talk about agreements. Developers, especially of large-scale projects, are always worried about, okay, I get my approval, but what if the rules change as I'm building out a long-term project that might take several years to implement? You can protect that with a development agreement that's authorized by state law. Subdivision agreements also provide some protection. And so these are the two of the most important agreements that typically are authorized by state law between property owners and local governments. They're very important documents. We can talk about them more if you have questions, but if not, I'm going to go to one more that we can do fairly quickly. That's the Williamson Act. If you're Williamson Act, go back. Okay, there you go. If you're going to go out into greenfield development, which isn't happening all that much these days, there are many thousands of acres in the state of California protected by the Williamson Act. And what it does, it gives farmers lower property taxes to encourage them to continue farming instead of selling for development. I've encountered this when I've done projects up in the Central Valley or more northern parts, areas of the state that really aren't all that heavily developed. You can non-renew your contract, but you have to give a 10-year notice. If you try to cancel the contract, it's very difficult to do because of the findings that must be made. But several years ago, I was working on a big project up in Tulare County, and we knew it was going to be a multiple year effort to obtain the entitlements. So instead of trying to cancel the contract, we just did a non-renewal notice, and it worked out about the same. It took about 8 years to go through the process. And so by the time they were ready to do the project, it just, the Williamson Act had just sort of naturally gone away. But that's only because it takes so long to do anything in California. But anyway, that's my little Williamson Act story.
Hey, David, we had one question when you were talking about development agreements. We had a question was, when was the last time you actually saw a new development agreement?
Well, I was working on a development agreement for my project in Monterey. Any major large-scale project is going to want a development agreement. I'm working on a project right now in northern part of the city that we want to have a development agreement. So they are a very useful tool if you want to preserve your entitlements once you achieve them. The Hotel Del Coronado has a development agreement that protects its master plan. And that has turned out to be extremely valuable because the airport authority is doing a new land use plan for the airport, uh, for North Island Navy base, and the new airport plan would severely limit what the Hotel Del Coronado could do, except for the fact that we have a vested development agreement. So the Dell's master plan rights are protected. So they are very valuable because you never know what government agency might come along and try to change the rules on you a few years after you have your project done, approved.
Are there any state actions that could supersede a development agreement?
Uh, yes, because development agreements only apply to local changes in local rules. They would not apply to changes in federal or state laws.
Oh, so when they go do something with greenhouse gases or VMT, that could affect your
Well,
project?
no, because what they're doing is they're structuring them so that the new VMT analysis and the climate action plan are requirements imposed on the local governments as they go through new projects. So if you already have your discretionary permits and you're protected by a development agreement, you will not be going to CEQA again. So you will not be doing a climate action plan analysis, and you will not be doing a VMT analysis. It's only if you opened up your local entitlements for a further discretionary review for an amendment that those would come into play. But since you're trying to amend your entitlements, they're not your amended entitlements wouldn't be protected anyway. Does that make sense?
Makes sense to me. Let's
All
press
right,
on.
let's go to CEQA.
That was a nice segue to CEQA, by the way.
Now, you could spend days and weeks talking about CEQA. In fact, I go to land use seminars where we do that. It's only lawyers will love this. But the concept of CEQA is actually really, really simple. It just requires that any public agency that's going to approve or implement a project has to consider the environmental effects. If they're going to be significant, you have to do an environmental impact report. If they're not significant or they can be fully mitigated, you can do a negative declaration or a mitigated negative declaration. It's a very, very simple concept. Next page. It's a very simple concept that has been dramatically complicated by lawsuits and tinkering with the statute. But the laws, the topics that an EIR normally covers are traffic, parks, public safety, all the things that we know about and hear about. I'm going to focus on two. The most trendy topics today of CEQA are traffic and climate action plan, air quality. Traffic, as you all know, the analysis is changing, has changed legally as of July 1, from a level of service analysis to a vehicle miles traveled analysis. And that is causing all kinds of consternation and heartburn on not only for property owners, but also the poor consultants and the lawyers that have to figure out how to do it right. But the concept of VMT is pretty simple. Whether you agree with it or not is another thing, but the concept is you want it as a policy matter. Some people believe it's a good thing to concentrate development in urban core areas that already have a lot of development. And the theory is that people in those areas won't drive as much, so there won't be as much greenhouse gas emissions, and there won't be as much traffic. On the other hand, if you're building out in the outskirts of developed area, people are going to have to drive more, so there's going to be more traffic impacts. Now, the side effect of that is the cost of doing development out in the outskirts is dramatically increased because of the mitigation measures that could be imposed. The fees that are being talked about, or the potential fees, are in the millions and millions of dollars for some projects. Whereas your mitigation measure for traffic in downtown San Diego, for instance, is going to be zero. Now, Matt and his team of excellent colleagues are working closely with the city of San Diego to revise what they're proposing to offset some of the dramatic impacts. But generally, that's the concept. There are lawsuits that are being filed against this process. And so there's a lot of uncertainty about how, whether, and when it will be fully implemented. But right now, it's the law, it's on the books. and we have to comply with it somehow. The statute that created VMT also said that the level of service no longer applies. So those of us trying to do EIRs right now are sort of in a rock and a hard place about what to do. So CEQA basically is a show your work statute. So what I'm advising my consultant team and my clients to do is just throw everything in. Throw in level of service, throw in VMT, analyze it every which way possible. Because you never lose a CEQA lawsuit for having too much information. You only lose it for not having enough. So again, there's a lot of discussion, a lot of uncertainty about this, and traffic consultants are really boning up on it. So if you've got a traffic analysis, talk to your land use lawyer, talk to your traffic consultant, and do the best you can, but don't leave anything out. Put everything in and do the best, because what you want to convince a judge if you're sued is that, Your Honor, we made every effort to fully inform the public about every possible permutation of the traffic impacts. That's about the best you can do right now with traffic. Climate change, the biggest local topic, of course, was the Court of Appeal just overturned the County of San Diego's Climate Action Plan. That's 100 and some odd page decision that sort of goes into intense minutia about why the county's plan was not acceptable legally. But the bottom line was the county tried to include a mitigation measure that allowed property owners to purchase greenhouse gas emissions credits out anywhere in the world. And I think that just, to the eye of the three judges on the Court of Appeal, was just too much, too far. If you're a consultant on this call or another lawyer on this call, the Court of Appeal did go through great pains to write a checklist of what they thought might work or what might not work. And if you're really into writing these climate action plans, you might want to try to use this opinion as a guide for how to do it and not do it. The Court of Appeal also did something unusual. Even though they talked at length about the various issues one by one, at the very end, they did create a checklist. So if you scroll to the end of the opinion, there's your checklist for you. So you may not like the result and you may not like the analysis, but at least the court took some effort to try to give a roadmap for success in the future. Any questions about that? I know those are controversial.
Well,
Angelique's question is really good. Is a city required to have a climate action plan? No, but a few years ago, the California Supreme Court struck down an EIR up in Los Angeles County because they said they had not done their greenhouse emissions gas analysis correctly. Again, a lot of technical reasons why, but like the Court of Appeal in San Diego, the Supreme Court tried to help all of us. And they, in their opinion, listed a few things that would work if you were doing a CEQA analysis for a project. And one of those was, if you're a local jurisdiction with a valid climate action plan and your project is consistent with your climate action plan, that is the beginning and the end of your CEQA analysis. You have satisfied CEQA if you have a valid plan and your project is consistent with the plan. The city of San Diego has a valid plan and had a valid plan at the time of this opinion. So the city of San Diego is ahead of the game on this one. The county is trying to catch up, and so are other jurisdictions. If you don't have a climate action plan, you have to do your GHG analysis from scratch. And that is very difficult to do and costs a lot of money. So that's the answer. Okay. The case name, I can see the questions too. The case name is interesting. You would think it would be some environmental group versus the county, but it's not. It's the Golden Door Resort versus the county of San Diego. And there are a lot of political reasons why the Golden Door was the lead plaintiff, and I'm sure Matt and all of us could talk about that story for a long time, but that's basically the name. So look, if you're doing a Google search, look for Golden Door versus county, and that case should come up. All right, next, let's go to the next one. We're talking about assessment districts. And again, this is just meant to cover all the bases very quickly, so I know I'm rushing this. Um, Assessment districts are designed to help property owners pay for things. The most common one for a large-scale master plan community is community facilities districts, the Mello-Roos Act, and that is just an assessment district imposed normally on vacant property by the developer before the houses are built. And when you buy the house, you get to pay some extra taxes for a few years. This pays for schools, roads, infrastructure. It can't pay for everything. It's only a certain percentage, but it does help finance things such as schools. There are infrastructure district, the statutes allowed that also can be created to finance infrastructure. Again, they are additional taxes imposed to help with these things. So they're all over. If you're going to buy a house, you always want to check to see if you're in a Mello-Roos district or not, and if you want to continue paying that. There's actually a controversy. I live in Rolling Hills Ranch in near Eastlake in eastern Chula Vista. There's a Mello-Roos district in Eastlake for the schools, but the schools are busing people all around. So there are homeowners whose children are being bused out of the districts in which the schools that they are paying for on their taxes. So there's a lot of angst and anxiety and parent groups fighting that. If they figure, if I'm paying a Mello-Roos tax for a certain school, my kids should be able to go to that school. So it's an interesting little political battle down here right now. Anyway, next page. Now, if you're trying to build anything, you're well aware of the Clean Water Act. There's the federal Clean Water Act and the state Port of Cologne, which is the state equivalent of the Clean Water Act. The Clean Water Act is the act that authorizes 404 permits if you're going to disturb a wetlands or a vernal pool, 401 certification, and these are sections of the code, the U.S. code, section 404, section 401, and then of course the water code is our state code that deals with our state Clean Water Act, which authorizes the water boards to issue their stormwater runoff permits, discharge permits, and then the California Fish and Game Code, upon which you get a stream bed alteration agreement, which is the state equivalent of a 404 permit that authorizes you to disturb wetlands. So the bottom line is if you're going to disturb any water area that might be a wetland, a vernal pool, a stream, or a river, you need permits, federal permits and state permits. And if you're going to discharge, you need a federal permit, the NPDES permit that's usually issued by the local water board. And then if you're going to if you're going to have stormwater running off, you need to comply with either the countywide order of the water board, or if you're a big enough entity, you can apply and obtain your own discharge permit. I just went off the board of directors of the Del Mar Fairgrounds, and we were in the throes of trying to comply with all the various discharge permits. At one point, our consultants told us that we had to comply with 5 or 6 different area-wide permits, and they were all contradictory and confusing, and they really didn't apply to what the fairgrounds does. So we are in the process of applying for our own, for the fairgrounds' own permit to cover, the 450 some odd acres. And the reason this is very important is because horses create discharge that is a pollutant that goes into the water. So the fairgrounds has spent tens of millions of dollars over the last several years to bring the fairgrounds into compliance, not only with the Coastal Act, but the federal and state environmental laws regulating stormwater and water runoff. Okay, next slide. If you're doing any greenfield development, you have to worry about complying with the federal and state Endangered Species Act rules. I won't go too much into them, but they are very complex regulations that generally require what they call a take permit if you're going to do anything that might harm a protected species. In addition, San Diego has its own set of regulations that require a site development permit. you need a great biology consultant and a pretty good land use lawyer if you're going to do anything that is going to require you to negotiate with the federal and state wildlife agencies to do a project. MSCP helps. If you're in an area that's designated for development, you have a lot of issues pre-approved, but you need to check and make sure that's still the case. And every local jurisdiction is going to be a little bit different. So, all right, next slide. Historic resources. If you're going to do anything that affects a historic resource, you need to worry about the federal, state, and local historic approvals. Now, the project I'm working on right now that's most relevant is I represent the Timpkin Museum of Art in Balboa Park. The Timpkin was built in the 1960s by a famous architect, and it has a famous set of architecture and a famous set of materials. So it's the very definition of a historic resource. So even though it hasn't been officially designated a historic resource, the Timpkin is in the process of wanting to do some expansion. They have a very small basement in the Timpkin Museum, and we would like to expand that basement. So we have a team of historic consultants and architects that are doing everything possible to design a basement expansion underneath that large entry area in front of the museum in a manner that will not have any effect whatsoever on the historic integrity of the building. If we affect the historic integrity, we have to go through CEQA, public hearings. It's a long, convoluted, expensive process with uncertainty in the outcome. If we have no effect on the historic integrity, we just need a building permit and a grading permit. So it's a very important issue if you're doing anything that's going to affect a historic resource. And by the way, if you're doing anything about Balboa Park, the entire Prado with all the museums is designated a historic district. So even though your individual building may not be designated historic, you have to worry about the historic district. Again, federal, state, local rules, complicated, difficult, always fun to work with. So next, schools. Oh, there's a question about the historic issue. Can you I can't see the whole question. Matt, can you read it? See it?
Yeah, let me see if I can find it here. Is there a specific age requirement for the Historic Resources Act and or local provisions? Do they apply?
In San Diego, I'm pretty sure that if your building is less than 40 years old, they will not take a look at it. If your building is greater than 40, don't hold me to that number. For some reason, 40 sticks in my mind. It may be 50, but I'm pretty sure it's 40. If your building is 40 years old, you may be required, oh, it's 45, thank you.
Yes.
Tim Hutter.
Thank you.
So the average, what I was saying, the city will require you to go through a process of demonstrating, just because you're 45 years old does not make your resource historic. Sometimes it's as simple as getting a letter from a historic consultant sort of listing the reasons why it's not historic. If there's a question, you may be required to do a full-blown historic study that may also demonstrate it's not historic. But if it's historic, then you're automatically kicked into a site development review process. So that is the way the city of San Diego works on a local level. For CEQA, even if you're not in the city of San Diego, if there's any question as to whether a resource your project may affect a historic resource, then CEQA requires you to go through that analysis independent of a local statute like San Diego has. So you're going to have to demonstrate one way or the other if you're going through a CEQA process, if there's any question about a resource being historic. Like for instance, you know, the Salk Institute is a historic resource. When they were trying to do their new master plan several years ago, it had not been designated, and the opponents of that project took it to the state and got it designated as a historic resource in an attempt to modify the proposed project. So historic process can be used as a weapon against development. In fact, I've heard some people in the BIA mention that as you start redeveloping the inner city areas the way the city wants you to, historicity is going to be a major obstacle, because if you go into the North Part, South Part, Burlingame, start naming any neighborhood in the older inner city areas, you have the chance of running into potentially historic resources. So despite the push to develop more density and more development in the older areas of the city, historicity is going to be a major issue as we move forward. So,
David, what kind of delay can you expect if you run into a historic resources issue?
well, the problem with historicity is that it can kick you from a ministerial process into a discretionary process. So that automatically means delay and more expense. The mitigation measures first, they're prioritized. First, you have to preserve the historic resource. And if you can't do that, you can incorporate it into your project. And if you can't do that, ultimately you can tear it down, but there is a mitigation, but it takes a long time to get through that process. And when you're in a discretionary process subject to CEQA, that also opens you up to lawsuits. You can drive downtown San Diego and see old buildings where the facades have been incorporated. In fact, one of the Fenton projects that I helped Fenton on a few years ago in Little Italy, I think it's built, but they incorporated the facade of the historic building at India and Date there. And the old electricity building at Broadway and railroad tracks, that's the facade, around the foundation of that tower. So that happens quite a bit. So that's how, but it just adds time to the process and expense to the process. And of course, the most famous one in San Diego is the Western Metal Supply building in the ballpark. That was actually a compromise. The Padres really did not want to do that. They wanted to move all the old buildings they could or tear them down. But Western Metal Supply was sort of forced on the design team, and now it's one of the most popular areas of the ballpark. So it was a lemon, it became lemonade. So it can work to your favor. So
do historical regulations vary by jurisdiction?
Well, you have to comply with the federal process and the state process, but yes, they can vary locally. The city of San Diego has a very complex technical process. Other jurisdictions, they do not. Other jurisdictions can just rely on CEQA and the state and federal processes. So, all right, schools real quick. School mitigation of impacts on schools are handled by state statute. There are limits. The BIA is always watching how this works. It's sort of a complicated formulaic process, but it's meant to be easier than just worrying. You literally do not have to go through a CEQA analysis for every single project for school mitigation. It's all statutory, and for the most part, it works well. Unless Matt, you want to talk about it more.
No, we can keep moving on. It's
all right. And then fine, let's go to one more. We need to go a little bit faster here, I think. There are all kinds of special local rules and regulations, climate action plans, inclusionary zoning. The list goes on and on and on. City of San Diego has its own local wetlands rules. The definition of wetlands varies from federal law to state law and local law. And this is just one more example of how if you've got the federal law all sewn up and the state laws all sewn up, and then you've got to worry about every single local jurisdiction and what they might be doing a little bit differently. So these are just some of the examples up here. Let's go to the next slide. These are some of my most fun ones. Believe it or not, I just find it fascinating. I get involved in so many projects that involve initiatives or referendums. Initiatives are allowed and referendum are allowed by state law and the California Constitution. And they only apply to legislative actions. And legislative actions are general plan amendments and rezones and specific plans. They do not apply to non-legislative approvals such as tentative maps and permits. But initiatives, you can approve legislative approvals by initiative. That's where I, the developer, I, the property owner, I want a general plan amendment and a specific plan. I write my own initiative, I get signatures, put it on the ballot, and it goes up or down. That is what Zephyr did in Del Mar, and it was struck down. Referendums can overturn legislative approvals by city councils. Like, for instance, Caruso's project in Carlsbad, it was approved unanimously by the Carlsbad City Council, put on referendum, and it lost. So they're going to get you one way or the other.
Yeah.
The thing about initiatives, developer-sponsored initiatives, and if I could take a personal point of order here, and I don't mean to offend anyone in the audience, but when you're a property owner and you have a great project and you love your project, you can't believe that everyone else loves your project. But developer-sponsored initiatives, every single one in San Diego County that I can think of the last few years has lost. And 80% of developer-sponsored initiatives statewide lose. So it's just not, in my personal opinion, not the wisest course of action to do a developer. Whereas if you have a beloved project that everyone wants, such as the new stadiums in LA County, then there are examples of doing initiatives that pass overwhelmingly, but they are something that everyone loves and everyone wants, and they had no controversy. If there's a hint of controversy with a project, chances of it passing are probably pretty low. Now, referendums are more interesting because it's very, very hard to get a referendum to qualify for the ballot. You only have 30 days from the day this local body acts. It costs a lot of money. But if you're in a small jurisdiction, it's easy, like Del Mar is easy. Small jurisdictions, it's easier to gather these signatures and do a referendum. Or if you have an opponent with a whole lot of money, it's not that hard to gather the signatures. But, you know, it is what it is, and I find myself involved with these more than I would want to be involved. Now, litigation, every single approval is subject to litigation. If it's discretionary, can be subject to litigation challenge. The most common litigation is CEQA. And the reason for that is it's the easiest lawsuit to win. If I have a big project and I had 600 different issues, and you get sued by an opponent that lists 600 issues, we can win 599 and lose one, and we lose the project. And we have to redo that part of the EIR. So it's just such an easy way to lose a project. Many developers and property owners negotiate, try to make their deals with the opponents in advance of the approval to head off a lawsuit. That happens a lot. Or they negotiate and settle afterward. That happens a lot. But it's the most commonly abused statute. Great projects are struck down by groups just wanting to make money, attorney's fees. I could go, there are essays and articles and long seminars about the abuse of CEQA. There are many attempts to revise CEQA. My one change to CEQA, if I could wave a wand and make it, would be the loser of a CEQA lawsuit has to pay for everything, period. Whether you're the property owner or the opponent. I think that would make everyone think twice about filing a lawsuit. But right now, the way the law is structured, if an opponent wins a CEQA lawsuit, they normally get their costs covered. If a property owner wins, they rarely get their costs. That's because of all kinds of nuances in the law. But I think loser pays, winner receives would eliminate a lot of the abuse. That's just me. That's my editorial commentary. Now, I saw Steve Whitman had a question.
Yes. He says, David, if there's one City of San Diego regulation you could change or get rid of, what would it be?
Several years ago, the city created a process that if I have a CEQA document approved by a lower level body, such as the hearing officer or the planning commission, even if the hearing officer or the planning commission were the final decision maker on the project, the CEQA document can be appealed to the city council. That is the most frivolous, ridiculous, stupid waste of time I have ever seen at a local level. And it just repeal that municipal code ordinance that allows an appeal of the CEQA document alone. Because last time I checked, the city council has never approved one of these appeals. So if there was a problem, if the planning commission was regularly approving bad secret documents, the council would be overturning them. But if there's no problem, why it doesn't exist? And it just, if you're a project opponent and you don't like a secret document, then file a lawsuit. But don't, these ridiculous appeals that waste money and accomplish nothing need to go. That's my personal editorial commentary.
All right, take notes, Mr. Whitburn. You heard him.
Okay, this is the last slide, miscellaneous regulations. Proximity to airports. The State Aeronautics Act gives our land use, our airport authority, not even the authority, but the mandate. The airport authority staff, I happen to know, hates doing these things, but they have to prepare airport land use compatibility plans. And they affect downtown San Diego, they affect Coronado, they affect Imperial Beach, they affect Point Loma. And if you have any property near an airport, Miramar, name it, Montgomery Field, you are affected by these plans. And what they generally do for safety purposes is limit what you can do on the property above and beyond the underlying zoning. Like for instance, the Hotel del Coronado in the newest version of the airport land use plan, that it hasn't been adopted yet, but it's going, would basically make the Hotel del could not be there anymore. So needless to say, when they started that process, we were a bit, we spent a lot of time, energy, and effort to protect the Del's entitlements. And so did the city of Coronado, because the Del generates 25% of the tax revenue for the entire city. Now, for instance, Miramar, when they did the land use plan for Miramar, it wasn't that bad because the federal government wisely over the years had been buying all the property around Miramar. So there wasn't that much private property to be affected. It does affect downtown San Diego, and there's a lot of angst over that. But the city of San Diego regularly overturns the airport authority, which they can do on a two-thirds vote. But it is an interesting statute. It has a lot of repercussions that I don't think were intended. I think the statute originally was intended to protect airports from new development. Like if you're out in the middle of nowhere and there's vacant land, it stays vacant. But for Coronado, it has been a nightmare because the airport authority has to go through the process, even though the entire city is very intensely developed. So there's been a lot of angst and anxiety in the city of Coronado about that project. So that is it. That is my, thousands of statutes, thousands of rules and regulations in an hour. But again, the point of this exercise is to demonstrate the difficulty and the complexity of any property owner if you want to do something with your property. And it's to, educate and inform the decision makers at the local, state, and federal level that this is not easy. I mean, I keep telling myself, if it was easy, I wouldn't have a job. But when it takes 7 to 8 years to get a project through all this process, and then be subject to 2 to 3 years of litigation with no certainty as to the outcome, there's got to be a better way. And so it would be nice if the people that make the decisions could focus on these types of issues and not try to solve all the problems at once. The CBIA every 6 months has a seminar for land use lawyers, and I go to that fairly often. I used to go every 6 months. But you sit in a room with 50 or 60 or 70 lawyers, and they all talk about how could CEQA be changed? Well, you come up with a list of 50 things. Well, not going to happen. What you need to do is think, I want to do 1 this year, and maybe do 2 next year, and 1 the year after that. Do them 1 at a time. Don't try to change the world in one fell swoop, because that's just a recipe for disaster. And it'll never happen. I've been going to these seminars now for 30 years, and they're still talking about the exact same issues they were talking about 30 years ago. And it's like, nothing has been accomplished. So
leave us with a little hope there, David. Leave us with a little hope.
Well, I'm saying, let's try to figure out one thing that everyone can agree on, and try to make things better. Like for instance, one thing I've seen bandied about for CEQA, even among the environmental community, is how about if you have a project that's consistent with the general plan, a specific plan, the zoning, and all those things were previously subject to an EIR, your project is exempt from CEQA because all the impacts of that project were already analyzed. Even if you need a discretionary approval, if you're consistent with all the legislative documents, you should not have to go through CEQA. So that would be one solution to making things quicker, easier, and faster in an area that has already been subject to CEQA. For instance, in downtown San Diego, if my project is consistent with the downtown community plan and the Center City Development Ordinance, I should be completely exempt from CEQA. There is no impact that hasn't been analyzed for downtown San Diego. Now, if I'm trying to amend them, yeah, but not consistent. That's another substantive change I would make. But anyway, there you go.
Well, yeah, we did have a question.
We have a bunch of questions.
So. Challenges, and as a project proponent, you need to decide to proceed with a mitigated negative deck versus an EIR. Can you explain the fair argument concept and how it would apply to a court ruling?
Unfortunately, the fair argument concept is a very low level. If I'm a project opponent and I can just make a fair argument, it doesn't have to be a good argument. It just has to be a fair argument that you left something out of your EIR and you should have analyzed it. The court will say you should have done an EIR. So that's why conservative lawyers like me, and I want to give a shout out to my colleague and very dear friend, Jeff Chine, who is the BIA's general counsel. He and I are both pretty conservative lawyers, and we talk about these topics a lot. And even though clients don't like the answer, you never lose if you go the extra mile in CEQA. So that would, if there's a fair argument, then you need to get to an EIR.
What do you think, this will be the last question, what do you think of the city's efforts underway over the last couple of years to improve the regulatory process, either through community plan updates or the mayor's concept known as complete communities, which is currently being discussed? What are your thoughts on that?
Well, my thoughts are going to be based on the perspective of what it was like. I started a lawyer. I became a lawyer in 1988, and I started practicing land use law back in the day when, I don't know if any of you remember, Carl Zobel was a senior partner at Gray Terry Ames and Fry, the firm I worked at, and Carl was the chairman of the Planning Commission. This is in the early 1990s. And he started the process to create what is now called Process 2000 and the brand new Land Development Code. Because back in the day, there was no consistency. Depending on where you were in the city, you could end up requiring 10 different permits or 12 different permits, and the processes were all different. And it was this convoluted, confusing, contradictory mess of zoning regulations. And Carl, as chairman of the Planning Commission, said this publicly and said, we have got to fix this. So during his tenure, he started the process of a brand new development code to make it simpler. That's why we have 5 decision-making processes instead of 15. That's why we have a very low number of permits instead of dozens. So there has been a lot of work done that sets the foundation. Now, if you weren't trying to get something done in the city of San Diego before the new land development code, you probably have no appreciation for how much better it is now than it was 20 years ago. But with that said, what I think the city staff is trying to do is build on that and make it simpler, and trying to make more projects fewer of the projects discretionary. If you're ministerial, you're not in CEQA. And ministerial permits are building permits and certain types of grading permits, as opposed to conditional use permits or plan development permits or site development permits that kick you right into a discretionary CEQA review. So I think their heart is in the right place, and I think it's a good intent. The pushback politically is always the community wants more discretionary. I remember one planning commission workshop when we were doing the new land development code in the late 1990s. We had come up with a long list of projects that were going to be considered ministerial to make them simpler, and the community pushed back hard. So about half the permits that we wanted to be ministerial ended up discretionary. So it's a constant battle between ministerial and discretionary, and that is at the heart of what I think is going on today. But with that said, a lot of success was achieved in 1999, 1998, 2000 with the Land Development Code. And for those of you, if you ever happen to run into Susan Golding on the street, you might thank her for that. She's underappreciated for that reason. And Matt, you were probably involved. You probably started at the BIA when we did all that.
Yes,
Yeah.
I testified on process 2.
So it's just a continue, like, is it great today? No. But is it better than it was? Yes. And it's constantly getting better. People are trying to make it better. So that's my long range opinion.
Well, that's the hopeful note we want to end this webinar on, that things are improving. Slow and steady wins the race. So hopefully it'll keep going that way in the city of San Diego. David, I want to thank you very much for your time, for your expertise, and your devotion to the industry and to the BIA. You have been immensely helpful to us, and your service to the industry is very much appreciated. So I thank you, and I thank everyone for listening in on the webinar. And we
Matt,
hope you
one more thing. Typically, when we do this seminar live, I hand out copies of this PowerPoint to anyone that attends. So if anyone wants, Matt, you can feel free to share the PowerPoint if you want to.
All right, we're happy to do that as well, Dave. Thank you so much. All right, thank you. Have a good day, everyone.
Thank you.